Oregon is now grappling with whether to give hundreds of people convicted of crimes new trials after the state's controversial law that allows non-unanimous jury decisions was declared unconstitutional by the Supreme Court. The issue? Doing so could be a logistical nightmare for the courts.
And we have a special report for you about this very issue. Our Joelle Jones investigating what this means for those wanting another chance to prove their innocence and those who are victims of crime.
You're talking about sitting in jail for 13 years knowing you didn't technically get a fair trial.
When Terrence Hayes was convicted in 2004, 2 jurors voted not guilty. Now he's fighting for a new trial after the Supreme Court declared non-unanimous jury decisions unconstitutional. The ruling forced Oregon, the last state to allow divided jury decisions, to update state laws this spring, but did not address the hundreds of cases with split jury decisions prior to the ruling.
That section doesn't really do anything unless we address the 300 or 400 or so Oregonians who have been convicted under non-unanimous juries and are awaiting a second opportunity to discuss their case.
And the backdrop for it all, what some say can't be ignored. The history of the law, which court documents suggest was based in anti-Semitism, but primarily affected Black people.
When you know a law is on the books that was based in discrimination and has played out in a discriminatory way for almost 90 years, and then it was found unconstitutional, I just think it's really important, if we want people to have faith in our justice system, that we go back and fix those mistakes.
Why, as we recognize as racist, aren't our leaders immediately just smacking it in the mouth and dealing with it?
At the time of Hayes' conviction, Oregon's acting Attorney General Ellen Rosenblum was the presiding judge. Now her office has the opportunity to change Hayes' life again.
The Attorney General has a choice. Does her office fight these people on retroactivity? Does she just let them go? Or even better, could she stipulate to retroactivity? Those are her choices as the respondent in these Ramos retroactivity cases. And every single case that's been filed, her office has fought the petitioner and said no retroactivity.
Despite publicly calling Oregon's non-unanimous jury law, quote, an embarrassment to our otherwise progressive state, end quote, Rosenblum asked the Supreme Court 2 years ago not to change the law. Then again last year, she urged the court not to make the decision retroactive, warning the courts would become overwhelmed with appeals. And she's not alone in her concerns. Retired Clatsop County DA Joshua Markey told KOIN 6, beyond tying up the courts, granting retroactivity would force victims to relive trauma and make it increasingly difficult for prosecutors to convict in cases of sexual assault.
There's a great deal of skepticism still about when women and girls and children come forward. And almost every verdict I've obtained has been 11-1 or 10-2 for guilty.
While concerns about how courts would implement retroactivity are valid, Hayes argues lawmakers have a responsibility to rectify the situation for those victimized by the now unconstitutional law.
The courts is a thing. I am a human being. I'm a person. My life matters. The time in my life matters. This moment of time that I have with my family and my friends matters, and I don't get that back. So when people sit there in their comfort zones letting that nonsense spew out of their mouth, they are absolutely valuing a thing, a concept, over a human being that thing and concept was supposed to protect.
For Hayes and others like him, retroactivity would not be a get-out-of-jail-free card. If granted, defendants would have the burden to prove their case was the result of a non-unanimous jury decision in order to restart their trials. There are more than 250 appeals so far, and the legislature was unable to pass a bill addressing retroactivity before the end of the session. Joelle Jones, reporting for KOIN 6 News.